State Court. Captain William D. Palmer, Judge, presiding. All persons for this court join. You're given 10 minutes to heard. May God save the United States of America, Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. Let me begin by introducing the panel. As you've already heard, I'm Judge Palmer. To my right is Judge Lawson. To my left is Judge Griffin. We will have a panel change after the first case, and Judge Evander will be joining us. We have switched the order of cases today. We will hear the CALAMIA case first, then the Kirby case. After that case, we'll take a break, and the lawyers are invited to join us for coffee in the lawyers' lounge if they want. We will then take up the Bryant case, 15 minutes per side on the criminal cases, 20 minutes per side on the civil cases. The appellant can save as much time for rebuttal as you like, and if you give me a clue on how much you want to save, I'll try and give you a signal when you get to that part on the clock. So with that, CALAMIA versus State.
Good morning. My name is John Middleton. I represent Mr. CALAMIA. I'd like to reserve 3 minutes for rebuttal. I believe this case is more than just about Mr. CALAMIA. The court is aware of the facts of the case. This is the case where a letter was sent to an attorney. In the letter, there were contingent threats made about the victim's family, and the attorney, pursuant to his bar-imposed obligation, disclosed those threats to the state attorney's office. I think it's more than just about Mr. CALAMIA, because it's about the attorney-client privilege, which I think is, in my opinion, the bedrock of our criminal justice system. Senator Day O'Connor once stated, "It cannot be too often stated that the greatest threats to our constitutional freedoms comes in times of crisis." And I'd like to draw an analogy here and say, Mr. CALAMIA is not a very pleasant person. I recognize that fact, and I think the things that he stated in the letter were not very pleasant at all. He's not a good defendant, so to speak. And because of that, I think a court might have a tendency to try to find some, to punish him for what the court thought it was inappropriate conduct. But the lower court, in this case, what it did, it skirted the protections given by American Tobacco and the Turney case involving the crime fraud exception. It went around those protections, and did so by finding that Mr. CALAMIA told his attorney to disclose what you need to, and that statement is supposed to mean that he's supposed to tell the world. If you look at that statement clearly was leaving in the attorney's discretion what to disclose. It says, you tell him what you want to, you tell him what you need to, but it wasn't say, you tell the prosecutor. That discretion is no more or no less than what every attorney has when he represents a client under the implied attorney-client privilege under the common law, as well as our Florida bar rules. The second thing the judge did to find that this communication was a non-privileged communication was find that the comments were not related to rendering legal advice. Now, he did this, it is our contention, he did this by relying upon incompetent evidence. In other words, evidence that should not be deemed admissible under the evidence code. And what evidence did he rely upon? He relied upon the bar disclosure, and that's the only thing he relied upon to allow these comments to come in, and then say, oh, the bar disclosure comments show that these are not covered by the attorney-client privilege because the attorney said he could disclose it if he chose to do so. It is our contention that the bar disclosure comments that were made by the defense attorney are not admissible evidence. There is nothing in the evidence code that says this is admissible evidence, and like the Kleinfeld case, found that there's a schism between the evidence code and the bar disclosure rules. So it's our position that the lower court, maybe not meaning to do so.
I guess I'm not particularly clear on how the process is supposed to work. The judge is supposed to have a factual basis adequate to support a good faith belief that there's no attorney-client privilege protecting a document. And I don't know why the rules of evidence that would apply at trial or an evidentiary hearing would apply to the information that's given to the judge to make that determination. I mean, it seems to me like the fact that there is a disclosure of a future threat of harm to someone ought to be enough to give the judge a good faith belief that that communication of the future threat is not privileged.
The reason I believe that the court, I think it isn't admissible because the Turney case and First American Tobacco case state that in a circumstance where remember the state alleged a crime fraud exception in their motion to compel. And under this crime fraud exception, you have to establish, you can't look at the document.
What case says that the evidence code applies to the information given to the judge to make that threshold determination that I can make an in-camera inspection of a document? That just doesn't make sense to me.
Well, I think based upon the Turney case and the First American Tobacco case, it says competent evidence must be adduced beside the document. And what you've done here is taken the document, basically read it to the court, and the court, in essence...
Your theory is sort of that if there's a non-privileged communication in a document to a lawyer, it can never be disclosed because it would have to be information about what's in the document that would form a reasonable basis for belief that it's not. And according to you, you can never tell the judge anything about the document itself because then you're using the document to prove that it's not a privileged document. So I'm having a hard time understanding how you would ever get to an in-camera inspection if the rule that you're applying is true, because you'd never be able to discuss anything related to what's in the document or disclose anything related to what's in the document because that comes from the document and that's not permissible.
Your Honor, I believe that there is not a specific case that holds that. I'm not suggesting that. I'm saying this case is an unusual case. You have to admit you don't see this very often. And I'm suggesting to you that there should be a rule or a statement by this court that says if you're going to breach the attorney-client privilege, that you should do so based upon some sort of evidence beside the document itself.
But the question is whether this document is privileged. And you're saying that the judge never should have been able to make an in-camera inspection of the document because no one could relate anything to the judge that indicates what's in the document itself, so he could never look at it, determine that it's not privileged.
I'm stating, Your Honor, that I think you should have competent evidence that's admissible, and I don't think an attorney's disclosure, I think the chilling effect on the attorney-client privilege of a future harm disclosure.
If the attorney discloses that my client has made a threat of harm, future harm to somebody else, why doesn't that fact indicate that the document's, if it's in a document, not privileged? Because a threat of future harm is, I don't think, ever given in order to obtain legal advice, or if it is, it would be in connection. If you're asking the attorney, how can I kill someone and get away with it, then that would be certainly the crime fraud exception. So, I don't see how that would be privileged communication.
I'm suggesting that this court go along with the other courts, other state courts, including the Maryland Supreme Court, Massachusetts, and the federal decisions that hold that a threat of future harm is not admissible evidence, period. And those courts, I've given you a notice of supplemental authority, and I'll read a quote to you from the Maryland court addressing this very issue, the threat of future harm. We agree with the Massachusetts Supreme Court that such disclosure is not sufficient to obviate the attorney-client privilege and admit these statements as evidence against the attorney's client, not only because of the chilling effect of the adverse, but also it pits the attorney as an advocate and advisor against the client when the client is charged with the crime. To prevent a Rule 1.6 disclosure, which is similar to our rule, to distort the attorney-client privilege and empower the attorney to essentially waive his client's privilege without the client's consent is repugnant to the entire purpose of the attorney-client privilege in promoting candor between attorney and the client. Moreover, it would violate our duty to maintain the integrity of the legal profession. I agree with you, Judge. There's not a case on point that says we can't do this. The judge can't do this, but I'm suggesting to you that this court should adopt a rule similar to what Massachusetts and Maryland and other courts have done, saying this is not admissible. And that's what I'm suggesting. There isn't a case that doesn't prevent it, but there should be, is what I'm suggesting to you, Judge.
Okay.
All right. This court in the past has, on many occasions, said that the attorney-client privilege is entitled to the utmost protection under the law. And I suggest to you in this case that the judge's way of doing this, not reaching the crime fraud exception that was alleged by the state, going around it by saying, oh, this is not privileged because I have this information and therefore I find it not privileged, is basically takes away the protections given to the attorney-client privilege by the American Tobacco Case attorney. I also believe that in this case, the court, not just touching upon the attorney-client privilege, the court made an error when it held that this was a violation of 836.05. The publication of these threats, these contingent threats, if something doesn't happen, I'm going to do something to the victim's family, the publication was caused by the borrower's duty to disclose. It was not caused by the direction of the client. It was not caused by...
Well, I guess that's an argument. I mean, they would say that it is, because they would say that the statement, make this as clear as you want, or words to that effect, to the prosecutor would have been a waiver of the attorney-client privilege and a direction to disclose the threats to the prosecutor.
There wasn't a direction, Your Honor. I just disagree with the court respectfully. The direction was you disclose what you need to, not you disclose it to the prosecutor. The statement was never that you disclose this to the state.
It was make this as clear
as you need to
the prosecutor as you need to. What in the world was he talking about if it wasn't the threats there? I can't figure out what that would apply to. Make this as clear as you need to if it wasn't the threats.
I believe that it was giving the attorney the discretion to do what he needs to do to accomplish the legal objective that he was trying to seek, which is get his probation terminated or get the GPS monitoring off of him. I'm not suggesting that his language or his threats were appropriate. I'm not suggesting that. But I think it was in the attorney's discretion to do so, to disclose or not to disclose. The attorney clearly stated in his testimony, my only reason for disclosing this is because of my bar disclosed duty. I'm not doing it to threaten Mr. Holmes. I'm not doing it to threaten the victim's family. I'm not trying to accomplish that. And the case law says that the disclosure, the purpose of the disclosure, the publication has to be to make somebody do something against their will. And that's not what this disclosure occurred in this case. The attorney disclosed it based upon his bar disclosure obligation. So I'm suggesting to the court that the lower court made an error of law when it said that it was a violation of 836.05, because the Duane case specifically holds that the purpose of disclosure has to be to force somebody to do something against their will. The attorney says he wasn't doing that. He was saying, I'm doing a bar disclosure. And in fact, if you look at the testimony before the court, the attorney said,
I'm not the cases that say it's the client's intent with respect to the communication that determines whether the attorney-client privilege applies, correct?
I agree with that, Your Honor, but I also think
if the letter had said, go tell the prosecutor that I'm going to kill this person if I don't get GPS monitoring removed as a condition of probation, what would your position be?
I think you would have a position that if that instruction was in there, Your Honor, it would probably be a waiver of the attorney-client privilege. I don't have a problem with you saying, if somebody says, you go tell the prosecutor I'm going to go kill the victim's family, I think that at that point in time you do have a waiver because it's clear instruction. But when you give the attorney the discretion...
Well, if the statement, you make this as clear as you want to the prosecutor, doesn't apply to the threat, what possibly could it apply to? I mean, that's where I have the hang-up with your argument, because, I mean, everybody knew, the defendant knew, everybody knew that the attorney was going to go talk to the prosecutor or talk to the judge and try to get that condition removed. So, I mean, of course, he was going to talk to him about that, and the nature of the communication was threats of harm if that was not the end result. So I'm having a hard time understanding what that would have meant if it was not a statement. You can tell the prosecutor that I'm threatening to do these things, or this could be the result. I mean, the way he couched it was, I won't be able to control myself.
Yeah, my belief, Your Honor, is, again, that it's the attorney testified he did not perceive that as instructions to tell the state the contents of the letter. The attorney specifically testified.
If it objectively says that, who cares what the attorney says about it?
Well, I think it's important to recognize an attorney has to have the discretion to understand what his client's trying to communicate. And what I'm trying to say is, if for a court to come back...
I mean, sure, if the client said, you go tell the other lawyer this, and the attorney decided not to, I mean, he would have the discretion to do that, but it still might be a waiver of the privilege if the defendant said, I want this disclosed.
If the attorney, a good lawyer would say, not a good lawyer, but a lawyer should say, you don't need to tell this to the other lawyer because you might get in trouble. Now, I'm not saying that if it's a threat to kill somebody, that's a threat of future harm, you have to disclose it. But if it's in a simple divorce case or something like that, the attorney would consult with the client and say, you better not do that. My problem is that you looked at the disclosures and then make the determination more or less in a bootstrapping manner, saying, okay, we find out what the letter says through inadmissible evidence, and then turn around and say, okay, we admit it in now. And that's what the problem that I have with it. May I sit down, please? Thank you.
May it please the Court, my name is Lori Hagan. I represent the Attorney General's Office in this appeal. I think defense counsel, his primary argument is that the Court did not follow the correct procedure to determine whether crime fraud exception to privilege was met. And the Court in this case didn't address that because as a threshold matter, they determined that the communication was not intended to be confidential. In fact, at the conclusion of this preliminary hearing, the Court said, wait a minute, either you two are missing the point or I am. Wouldn't you agree that if this is not confidential, if this is not meant to be, if this is meant to be disclosed to third persons, wouldn't you agree that we don't need to get to the discussion of whether the crime fraud exception is met? And defense counsel said yes. So then the Court said, well, I have testimony here.
I mean, you still have to address the crime fraud issue, really, don't you? I mean, because if ultimately, if the threat wasn't intended to be disclosed, it's not a crime and there would be no violation of probation.
Well, I think there is a case from this Court, Black v. State, which looked at the allegedly confidential communication in determining whether or not it was privileged. They had to look at it. I mean, how else would they know? You know, they had to listen to the taped phone calls to see if a third party was listening and if the defendant knew a third party was listening. And I think really as a practical matter, at some point they have to, you have to examine the confidential communication. And in this case, the Court didn't look at the letter. What the Court did was ask defense counsel, or not, the Court didn't ask, the state attorney asked defense counsel, what did you disclose? And he testified, well, the letter said you make it as clear to Wayne Holmes as you need to. Wayne Holmes is the prosecutor. And then the state attorney said, okay, what did you disclose? And the defense counsel just testified as to the portions he has disclosed. Now, the U.S. Supreme Court case, which is the leading case on this issue about the crime fraud exception, says that the proponent of the exception has to introduce evidence apart from the disputed documents to make out a prima facie case. However, they can use any evidence they have lawfully obtained. And in Zolin, which is the Supreme Court case, the state had obtained portions of the privileged communications legally from a confidential source. And the U.S. Supreme Court said that was fine. The Court didn't look at the actual documents. The Court looked at excerpts that the proponent had from another source, and that's what we have here. The state attorney had lawfully obtained this information. Yes, it was pursuant to an ethical disclosure, but nonetheless it was properly obtained, and that's what the Court looked at. And I'm not saying necessarily the Court couldn't have also done an in-camera inspection, but either way, what they did was proper here, because the only thing he looked at was what the state attorney had properly obtained, which was the specifically the direction, tell the state attorney as much as you want, and here are the threats I'm making, and here's what I'm going to do if I don't get what I want at this hearing. So I think in either instance, the analysis was proper, that this decision is governed by an abusive discretion standard, and there was ample evidence for the Court to have made either finding. And as far as the violation of probation, it's not the attorney's subjective belief as to whether the defendant wanted his threats communicated. I think the case law and the statute itself says that it's the defendant's intent that's important, and the Court had not only the attorney's testimony but the letter itself, which said, make this as clear to the prosecutor as you need to. And I think that, there's sufficient evidence there to find a violation of probation and find that there was a corruption by threat of a public servant.
Should it concern us that the trial court came up with his own legal theory as to why the document was admissible or what wasn't privileged?
I don't think he came up with his own theory. He was reading directly from the statute, as was the state attorney. The first section of the statute says a communication is confidential if it is not intended to be disclosed to third persons. State attorney read from that during his argument. Trial court also read from that and said, this is the first element. Wouldn't you agree? And both attorneys said yes. I don't think that's a separate legal theory. And I think the fact that the court ultimately cited a case which wasn't discussed at the hearing, it was a case directly in point with all the other cases that were brought to its attention. And in fact, if you shepherdize one of the defense's cases, that particular case is the first one that comes up. And I think there's certainly nothing wrong with a court knowing the law and applying the law, and if necessary, checking to make sure that the law that's been cited by the attorneys is correct. I mean, this wasn't a case where the court jumped in and started questioning witnesses and said, well, let me do some research and see if I can overcome this affidavit, such as some of the cases which are cited by defense counsel in his brief. If there are no further questions, I'll rely on my brief. Thank you.
Thank you, counsel.
Not much time, but my problem, but I think this court needs to look very carefully at it, is this peek and see approach that the court is doing in this case. They state the court's not looking at the letter, but in fact the court is looking at the letter by having somebody read it to them. And that's what's happening here, is you're allowing the attorney-client privilege to be pierced without the due process protections that Turney and the First American Bank give to you. The court here said, we're not going to bother ourselves with that. It's not intended to be privileged because I know what the letter says. And that's what the court did. And I believe that has such a chilling effect, that approach on the attorney-client privilege, that this court should not sanction it. And I urge you to read the supplemental authority that I submitted. I apologize for being late, but I think it's right on point, and the court should take the approach that other states have. Thank you.
Thank you, counsel.